Robert Bateman here with another edition of the Privacy Corner with Privado.ai. So this week, the House doesn't always win. A UK gambling firm has lost a case alleging that they failed to get consent for direct marketing and cookies. Some very big implications for the UK GDPR in that one. Google is accused of transferring data from the US, unusually, to China and Russia. And New York has passed a pretty bonkers and strict health privacy law. So first up, just let me tell you about the Technical Privacy Summit Bridge 2025 taking place next week. That's February the 5th and the 6th. I'll be on two panels there about the regulatory landscape in the US and the EU and ad tech privacy risks. Registration link in the comments. So the UK High Court, well, the English and Welsh High Court, has heard a case about gambling, and it has big implications for how controllers should be interpreting the UK GDPR rules on consent. It's a great judgment, very interesting, very deep, quite nuanced. I do recommend you read it. I'll put a link in the newsletter as usual. So the anonymous or pseudonymous claimant in this case, RTM, spent thousands of pounds gambling on Sky betting and gaming app between, well, it started in 2009. The relevant period here is 2017 to 2018. So there were two successive data protection laws in place throughout this period, the Data Protection Act 1998 and the UK GDPR. And the claimant here alleged that SBG, Sky Betting and Gaming, profiled him and targeted him with direct marketing using certain data collected to comply with gambling industry regulations. So SBG was obliged to collect certain data about users' behavior, like their time spent gambling, their total spend, and suppress users' accounts once they reach a certain threshold. This is to avoid problem gambling and gambling addiction. But unless and until a consumer met that suppression threshold, SBG would use this safer gambling data, as it's called, for marketing purposes. So, for example, RTM, the claimant in this case, often gambled in the morning. This is seen as a telltale sign of problematic gambling behavior. But SBG used this information to send RTM marketing and special offers in the morning when he was up gambling. So there are several allegations here under several laws. In the end, only two things matter. So he said there was no lawful basis for this processing, transparent and unfair. They were processing special category data about his health, and they'd violated several principles of data processing, and also that they'd failed to get consent for cookies or marketing under the e-privacy directive law in the UK. Also, there's a claim under a tort of misuse of private information. So there's some debate about whether SBG actually got consent for these things. The focus of the judgment, though, is whether RTM was even capable of providing consent given his issues with gambling. So based on the two data protection laws in place throughout this period, the judge gives a kind of three-step test for establishing whether consent meets the required legal standard. So firstly, there's the individual's subjective consent. So in this case, whether RTM's ability to consent was impaired by his gambling issues, the quality of autonomy in the decisions made about consent. So in this case, whether RTM was given the necessary information to make an informed decision, privacy notices and so on. And thirdly, the controller's evidential basis for relying on consent. So whether the controller can demonstrate, as is required under the UK GDPR, that they had RTM's consent. Now, the judge found issues with all three of these steps of the test and eventually concluded that SBG had used cookies and sent direct marketing unlawfully. So the claimant won, the gambling firm lost. This is not routine for data protection cases. They're often unsuccessful, so it's quite significant. There will be damages involved, most likely, but the decision about that will be made later. So the main thing here, as I mentioned, is this idea that RTM, given his state of mind, was not capable of consenting. So does that mean that controllers need to understand the mental state of every single data subject from whom they request consent? Not really, according to the judge. Businesses cannot operate at the level of inquiring into every individual customer's subjective state of mind, she said. But they have to balance the commercial benefits of data processing with respect for individual autonomy by factoring in decision points about consent that kind of optimize people's decision making. So there's a really nice passage in the judgment here that gives the kinds of things that controllers should be thinking about. So providing good quality, accessible, relevant and accurate information to guide decision making, taking steps to focus individuals' minds soberly and separately on the consent request, and avoid distracting people with the attractions that might come from consenting. So in this case, special offers and free bets and so on. So a really neat judgment. Do give it a read in full. It's long, but it's well written and some interesting insights into what consent really means. Now over to the US, there has been a complaint against Google by the Electronic Privacy Information Centre, so EPIC in the US, and also the Irish Council for Civil Liberties Enforce Unit, operated by Johnny Ryans. And this complaint is under the Protecting Americans' Data from Foreign Adversaries Act, the PADFA. So this passed last year, and I'll tell you a bit about what the law requires. But the groups here allege that Google exposes personal data about people in the US, including sensitive information and their employment with the military and intelligence community. So there's this kind of national security angle they're going for here. And the complaint is all about the real-time bidding process, so RTB, the ad tech ecosystem operated by Google. Now, this law, last April, the US has had a fairly modest law about data transfers. So it's about not transferring personally identifiable sensitive data to foreign adversary countries, and at present that includes Russia, China, North Korea and Iran. Now, unlike Chapter 5 of the GDPR, the PADFA is quite limited in scope, so it applies to data brokers and it only covers certain types of data, and it's riddled with the sorts of exemptions and safe harbors that we've come to expect from US privacy laws. So the complainants explain or allege how Google's RTB system collects personal data about US individuals, such as their locations, their political views, their health and ethnicity, and online behavior. You can see the IAB's taxonomy codes here for the relevant period. So we've got things like defense industry, casinos and gambling, relevant to the last case there too, mental health, Judaism, all these kind of quite sensitive characteristics that Google allows advertisers to target on the basis of. And the complainants say that Google shared this data, has shared at some point, with businesses like Tencent, based in China, and a Russian demand-side platform called RuTarget. So they have both previously been listed as certified participants in the RTB system. Now, Google has cut ties with some of these partners after becoming aware of their foreign adversary status. But the company says that non-disclosure agreements mean it can't reveal whether it continues dealing with foreign adversary companies. So the complainants here do not think that's acceptable and say it leaves a lot of scope for unlawful processing. According to ICCL data, they have obtained it from Google. So Google shares personal information about US individuals around 31 billion times per day. And the concern here is about an alleged lack of kind of downstream control over what happens to that data once it leaves the US or the RTB system per se, and the allegation that this breaches the PADFA. So the complainants want the FTC to launch an investigation into Google, order them to stop any unlawful collection and disclosure about US individuals, and implement a data minimization, protection and deletion program. So just an interesting case, I think, because we're used to seeing data transfer cases going the other way to the US from, for example, the EU. And this law hasn't seen much action yet, so we'll see how this one develops. Finally, New York has passed a health privacy law that could be pretty problematic for many companies, I think, operating in the kind of health space. So the law targets regulated entities, and that means any entity that controls the processing of regulated health information of an individual who is a New York resident. So a New York resident, theoretically, who is located anywhere, people in New York, so anyone physically present in New York, or companies that are located in New York and control the processing of regulated health information. So thinking about this, it's a pretty broad scope. I mean, for example, the coverage. So thinking about this, that is a very broad scope. It would in theory apply to, for example, a French health app intended for the EU market with one New York resident among its users, whether that user's in New York or not. A UK health app with one British user who uses the app while on vacation in New York, or a New York-based healthcare app whose users live exclusively in Australia. All of those companies, I think, would be covered by this law. So regulated health information is also pretty broad. It takes a lot from the Washington My Data Act in some areas. So regulated health information is any information reasonably linkable to an individual or device, collected and processed in connection with physical or mental health, and it includes location or payment information that reveals something about their health, and any inference drawn or derived from that data. And there are only a certain set of permitted uses of this type of data. So it includes things like internal business operations, which excludes marketing and advertising, and protecting against illegal activity. You can use regulated health data for that. You cannot use it for research or any other purpose than these listed, unless you have a valid authorization from the individual. Now, a valid authorization is an incredibly high bar to meet. It needs to be made separately from any transaction, can't be made within 24 hours of the individual creating an account or requesting a service, and it needs to be kind of separate for each processing activity. So it's kind of a ban. I mean, this is a very high bar to meet, and could apply to lots of companies in the health space. This law has passed, so get ready. It takes effect in 1 year. Thank you so much for your time and attention. I've been Robert Bateman, and I'll see you next week.